Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, Criminal Law and Procedure Core Doctrine, Homicide, Inchoate Crimes, and Defenses. Let's begin. Substantive criminal law questions are element questions. The examiner wants to know whether a mental state matches an act, whether causation exists, whether a partial defense reduces liability, or whether an inchoate crime merged or survived. Precision matters. Begin with the charged offense. Identify actus reus, mens rea, causation, concurrence, and attendant circumstances. Then consider defenses. For homicide, also classify the killing by malice, mitigation, and statutory degree. Actual and proximate cause. For homicide, the defendant's act must be both actual and proximate cause of death. Actual cause usually means but for cause. Proximate cause asks whether the death was a foreseeable result. An intervening cause breaks the chain only if it is unforeseeable and sufficiently independent. Murder malice. Malice aforethought exists through intent to kill, intent to cause serious bodily injury, depraved heart recklessness, or felony murder. Malice does not require hatred or long planning. Premeditation and deliberation. First-degree premeditated murder requires the defendant formed the intent to kill after reflection. The time can be short, but there must be some evidence of planning, motive, or manner suggesting a considered decision. Depraved heart murder. Depraved heart murder involves reckless conduct creating a very high risk of death with conscious disregard. Shooting into an occupied room or driving extremely fast through a crowded area may qualify. Ordinary recklessness is usually manslaughter, not murder. Voluntary manslaughter. Adequate provocation reduces murder to voluntary manslaughter if it would inflame a reasonable person, actually inflamed the defendant, occurred before reasonable cooling, and caused the killing. Words alone traditionally are insufficient, but modern statutes may be broader. Imperfect self-defense. Some jurisdictions reduce murder to voluntary manslaughter when the defendant honestly, but unreasonably believed deadly force was necessary. It negates malice but does not fully acquit. Felony murder. Felony murder applies to killings during commission or attempted commission of a qualifying felony. Common predicates include burglary, arson, rape, robbery, and kidnapping. Limitations are heavily tested. The felony must be independent of the killing. The death must occur during the felony or immediate flight, and liability may depend on whether the jurisdiction follows agency or proximate cause theory. Larceny. Larceny requires trespassery taking of possession and carrying away personal property of another with intent to permanently deprive at the time of taking. If the defendant initially takes without intent to steal, later intent may not be larceny unless continuing trespass applies. Embezzlement. Embezzlement requires lawful possession followed by fraudulent conversion. Employees with custody usually commit larceny. Employees with authority to control property may commit embezzlement. False pretenses. False pretenses requires obtaining title by intentional false representation of material past or existing fact. The victim intends to transfer title because of a lie. Larceny by trick. If the defendant obtains possession, but not title, by fraud, the crime is larceny by trick. Robbery. Robbery is larceny from the person or presence by force or threat of immediate force. The force must be connected to the taking or escape. Burglary. Common law burglary requires breaking and entering the dwelling of another at night with intent to commit a felony inside. The intent must exist at entry. Attempt. Attempt requires specific intent to commit the target offense and an act beyond mere preparation. Modern tests use substantial step, strongly corroborating criminal purpose. Because attempt is specific intent, one cannot attempt an unintended crime, such as attempted felony murder under the traditional logic. Impossibility. Factual impossibility is no defense. If the defendant tries to pick an empty pocket, attempt exists. Legal impossibility may be a defense where the completed act would not be criminal even if facts were as believed. Withdrawal from attempt. Common law generally does not recognize abandonment once attempt is complete. Some modern jurisdictions allow voluntary and complete renunciation. Solicitation. Solicitation is complete when the defendant intentionally asks or encourages another to commit a crime. If the solicited person agrees, solicitation may merge into conspiracy. Conspiracy. Conspiracy requires agreement and intent. At common law, no overt act was required, but many statutes require one. The agreement may be inferred from coordinated conduct. A single defendant cannot conspire with only an undercover officer under the bilateral approach, but can under unilateral statutes. Pinkerton liability. A conspirator may be liable for substantive crimes of co-conspirators if committed in furtherance of the conspiracy and reasonably foreseeable. Accomplice liability. An accomplice must aid, counsel, encourage, or facilitate the crime with the required intent. The accomplice is liable for the target crime and natural and probable consequences in many jurisdictions. Withdrawal requires repudiation and efforts to neutralize prior assistance. Self-defense. A person may use force reasonably believed necessary to prevent imminent unlawful force. Deadly force requires reasonable belief of imminent death or serious bodily injury. Some jurisdictions require retreat before deadly force if safe, but there is no duty to retreat in one's home under the Castle Doctrine unless the defendant was the initial aggressor or co-occupant rules apply. Defense of others. A person may defend another if the defender reasonably believes the other person could use self-defense. The modern rule focuses on reasonable appearance. Defense of property. Non-deadly force may be used to prevent unlawful interference with property. Deadly force may not be used solely to protect property. Duress. Duress requires threat of imminent death or serious bodily harm, reasonable fear, and no reasonable escape. At common law, duress is not a defense to intentional homicide. Necessity. Necessity justifies criminal conduct to avoid a greater imminent harm from natural or non-human forces. It is usually unavailable if the defendant caused the situation or for homicide. Insanity. M. Nathan asks whether, due to mental disease, the defendant did not know the nature and quality of the act or did not know it was wrong. Irresistible impulse asks inability to control conduct. MPC asks lack of substantial capacity to appreciate criminality or conform conduct. Entrapment. Entrapment requires government inducement and lack of predisposition under the subjective test. Merely providing an opportunity is not inducement. California criminal law has specific statutory definitions and homicide reforms, including limits on felony murder and natural and probable consequences murder liability. California essays require California statutes. MBE questions use the majority and common law formulations unless a statute is supplied. Malice aforethought is not the same as premeditation. Felony murder needs an independent felony. Assaultive felonies may merge. Theft crimes turn on what the victim transferred, possession, custody, or title. Attempt requires intent to commit the target crime even when the completed crime would require less. Duress is generally not a defense to intentional murder. Substantive crime questions often provide enough facts for multiple offenses. Choose the most accurate liability. If the defendant asks another to commit a crime, think solicitation. If they agree, conspiracy. If they take a substantial step, attempt. If they assist another, accomplice liability. For homicide, grade the killing last after malice and mitigation. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.